Now, we'll proceed with the legalities and the franchise agreement. So, I will now call on Attorney Familaran. Attorney Ton,
Hi, Joms. Good afternoon.
good
Thank you.
afternoon.
Thank you for
Okay.
all the attendees.
Okay. Sige.
Okay, so right now I will be discussing with you the legal aspect of franchising. So once you have decided if you are really ready to grow your business through franchising, and then you have thought of how to go about it and what to consider in your operating manual, the next step, which is mostly overlooked by most people, kasi sa kanila, contract lang yan eh. It could easily be talk about, lagay lang dyan sa kasulatan lang na sino ba yung ka-franchise mo, how much, and for what period, okay na. But in my talk for today, I would want to share with you the importance of understanding how to have a comprehensive franchise agreement. And towards the end of my short talk for today, yung objective ko lang naman talaga is to be able to equip each one of you to have a working knowledge on how to spot a poorly drafted franchise agreement, and for you to understand ano ba yung dapat nakalagay sa franchise agreement, apart from, of course, the franchise fee and how long the franchise would operate. Okay? So let's have for a better facility of the discussion, para mas maayos and mas compartmentalized, I have divided the discussion into 5 subtopics. First is the contract and its importance. Second would be the franchise agreement in itself. The third would be the usual problems na nakakaharap ni franchisor and ni franchisee. And 4 would be other miscellaneous concerns in franchising. This would include relevant laws such as labor law, e-commerce law, and of course, the intellectual property law. And then the last part of my discussion would be our usual and I think reasonable suggestion of putting up a separate franchise corporation, apart, of course, from your existing business entity. Say, for example, you already have a sole proprietorship operating your main business, or a partnership, or even a corporation already. We always advise our clients to put up a separate franchise corporation, the reason for which we will be discussing later on. Okay? So let's go through the basic first. What is a contract? Well, it is a boring definition under the law, but it is the meeting of the minds between the parties, the franchisor and the franchisee, as to the object and the consideration. Now, from this definition, you will gather the three elements of a contract. Absent one of these elements, yung contract is not void, but it can be canceled for being voidable. First, we have the consent. We have to make sure that the both parties consented to enter into a specific contract. So si franchisor and si franchisee, dapat they are both legally capable at walang legal impediments to enter into a contract. Kasi for example, you engage a franchisee, which is a corporation. Make sure na may consent and may authority. May board resolution ba sila to enter with in a franchise agreement with you? And ikaw yourself, are you as the representative of the franchisor, do you have the proper authority from your board or from your partner through a partnership resolution to enter into a franchise agreement? Second, the object. Ano ba yung object na tinatawag sa contract? Specifically in the franchise agreement, it is the grant of the privilege to operate the business of the franchisor under your particular system. Okay? And third, of course, the consideration. Consideration is magkano ang pinag-uusapan. Of course, we have the franchise fee. Another principal consideration is the royalty fee, which has been distinguished exhaustively by Joms in his earlier discussion, but we will also go through later in our subsequent discussions. Now, you will notice that a contract is not required to be in writing to be valid. Meaning, all contracts, even if it's verbal or electronically agreed upon, is valid. and you may not be aware of this, but in your daily existence, in your daily operations of your business, especially those engaged in online selling, online distribution, you have to be aware na yung mga pinopost ninyo, your conversation nyo with your customers can create a valid contract. So one sound advice is you have to be careful of those words posted in your pages. It has to be a disclaimer para magkaroon naman ng limit ang liability ninyo, and magkaroon din ng definition yung scope ng inyong obligation towards your clients. Okay. So if you're going to ask me, is it necessary that a contract be in writing? Of course, any lawyer would say yes. Why? Two reasons. First is for security purpose. Siyempre, kung ikaw si franchisor, you will be allowing somebody to use your brand, to operate your business, duplicate your business. It's necessary, it's very important, and it's for your security and peace of mind that it is in writing. It's a physical contract is in existence para anytime na magkaroon ng dispute, magkaroon ng gray area sa interpretation ng rights and obligations ni franchisor and yung franchisee, you just resort to the contract. Okay? And second purpose is for evidentiary purpose. In the operations of the business, hindi maiiwasan na magkaroon ng legal issues between the parties. So several issues can come up, and if these issues are not resolved, of course, it would end up in court. So if you don't have any document in writing, it's very impossible or it's very difficult to secure your success when these legal issues between the parties escalates into an actual court battle. So that's the importance of having a franchise agreement. Most people that I have met in practice, nakakarating kami sa court kasi walang agreement in writing. Why? Because they trust each other so much. Trust is good, but then again, when it comes to legal rights and obligations involving finances, involving your own business, it is always safe to have it in writing. Why not? This is not to prepare for an actual legal dispute or para paghandaan or i-foresee na may away, but this is to secure your interest. At the end of the day, you know that you have extended your right to another person to duplicate your business, but then again, you're safe and sound, knowing that your rights, whether to claim anything against that person or to enforce your right against that person, is black and white and in writing. Okay? So let's go to the franchise agreement itself. This is the main topic of this discussion. Okay? So by definition, the franchise agreement from our previous discussion, it is the contract ideally reduced into a legal document that defines the respective rights and obligations of the franchisor and the franchisee. So essentially, the written contract itself, it is also a security not only for the franchisor but also for the franchisee, because it serves and it stands as his license, proof that he has actual license to operate business under your system or under your brand name. So what should you look for in a franchise agreement? A franchise agreement generally it consists of around 50 pages. But in today's webinar, I will only be discussing with you the most significant points and principal considerations to look for in a good franchise agreement. What are these? First, the trademark, patent, and signage usage. Second, the franchise fee and other costs of investment. Third would be the royalties and other fees. Fourth, the operating manual. Next is the assigned territory, and also the duration of the franchise and renewal rights, the training and ongoing support, and the advertising. Okay, let's go to the first, the trademark, patent, and signage usage. Trademark applies, first, for starters, trademark applies to your logo, to your mark, yung mga drawings ninyo sa business that identifies your business. Patent applies to invention or mga machines that you have uniquely developed in order to further your business. And signages also falls under trademark. Okay. So I would assume at this point, if you are considering expanding your business through franchise, that you have already secured registration for your respective trademarks, because that's one basic step towards actually growing your business, that you have registered it before the Intellectual Property Office. Why is it important that the franchise agreement has to have a separate provision para sa trademark? Ang importante kasi, when you franchise off your business, the trademark itself has a separate value. It has a goodwill. So the nicer the identity, the logo, mas maganda sa recall, mas attractive sa customers, sa clients, and sa market, the more value you can command. So it's an additional premium to the franchise fee that you will add on. So before you are able to extend to your franchisee the right to use this trademark, dapat sa'yo ito, legally owned by your business or by your company or by yourself. And this can only be secured if registered siya sa Intellectual Property Office. Now, a good franchise agreement has to define and limit the right of the franchisee to use that trademark or that signage. Dapat hindi siya too general or too broad that the franchisee would have the liberty to use the trademark in all products. Dapat defined that this signage should only be placed at these portions of the store if there's a physical store, or should only be used in these kinds of advertisements, and that the trademark should only cover the products that are actually distributed by the franchisor. Kasi in most cases, if the franchise agreement does not include a provision on trademark, or the provision is too general, na parang nakalagay lang is the trademark is owned by the franchisor, then the franchisee is free. So he has the liberty to use it any which way he can. So that's the danger of not having a comprehensive and exhaustive franchise agreement. Okay, next thing to look for is the franchise fee and other costs of investment. So si Joms earlier have already discussed at great length yung definition ni franchise fee at versus the royalty fee. Now, from the legal perspective, the franchise fee is a one-time payment, of course, except upon renewal, that covers the privilege granted to the franchisee to operate the system. So, pag nagpirmahan na kayo ng franchise agreement, kaliwaan sa franchise fee, that is non-refundable. Yung iba nagre-reklamo, attorney, hindi naman kami tumuloy. Hindi man kami tumuloy kasi nagkaroon ng ibang problem. I should refund my franchise fee. No, because once you engage with this prospective franchisee, you've already lost the opportunity dun sa ibang franchisee for that area na interested, which you lost because you granted the privilege to this initial prospective franchisee. So that's the reason why it's not refundable. Okay, so nabigay ko na sa iyo opportunity, but for some reason, nag-back out ka, you cannot get a refund. Okay? So that should be clear in the franchise agreement. Now, another thing about this, as discussed by Joms, the franchise agreement should specifically enumerate ano ba yung inclusions ni franchise fee. Kasi yung iba, as a come-on to their franchises, they would say, package, 50,000, ganyan, ganyan, ganyan. So it's very, very low. So parang, oh sige, I can afford that, 100,000. But then again, they did not disclose properly because the franchise agreement is very broad. Hindi nakalagay na, ay, meron pa palang cost of investment, meron pa palang ganito. And the franchise agreement should also, if not the operating manual, then the franchise agreement should provide kung mayroon ng initial inventory supplies included dun sa franchise fee. Okay? And of course, the franchise agreement should make it a point to state that the franchise fee is payable at a certain day upon the signing, and it's without need of demand. That's very basic essentially for all contracts. Next is the royalties and other fees. So, ano naman si royalty and how is this different from the franchise fee? If the franchise fee is a one-time payment for the grant of the use of the business, si royalty fee is being paid by the franchisee as a recurring fee. Recurring because si franchisee is granted the privilege to earn revenues regularly from the use of the business. So separate si franchise fee, separate si royalty fee. A good franchise agreement will help both parties understand that these are two different fees and there's no overcharging or double charging. Okay? So it's also for the benefit of the franchisee who is sometimes lost na parang akala nila mag-franchise fee na wala ng royalty fee. Okay? But then again, we can customize how royalty fee is determined, how royalty fee is to be paid. Next is the operating manual. Like what Joms have mentioned earlier, it is the Bible for the entire operation of the system. Now, a good franchise agreement has to make an adequate reference to the operating manual, whether as an organic provision, meaning whether nakalagay na siya sa contract, reproduced in the contract, or as an integral part, as an annex, as an appendix. Why? Because if hindi nilagay ni attorney na part ng franchise agreement si operating manual, so kahit may breach itong si operating, kahit si franchisee continues breaching or violating the guidelines or the procedures provided in the operating manual, it will not provide the franchisor with an opportunity to cancel the contract. That is why a good franchise agreement must necessarily indicate that any breach of the operating manual must necessarily mean a breach of the franchise agreement itself, thereby giving the franchisor a more leeway to understand or to determine kung gusto na ba niyang i-cancel yung franchise agreement with this particular franchisee na sakit sa ulo. Okay, next is the assigned territory. The assigned territory is the geographical or demographic area provided in the agreement in order to identify and fix the area of operation of the franchisee. So this is not merely conjured up by the franchisor. Once you get to understand how a franchise works, you'll understand that si Joms, as in through his profession, would actually gather data, information, statistics, or even survey to understand which is the best territory to be assigned to a particular franchisee. Hindi porke may available commercial space si franchisee or may available lot si franchisee, he can already offer that to be the assigned territory or store. Hindi pwede yun kasi the first consideration is the demand of the consumers and the marketability of the product in that particular territory. So, walang discretion si franchisee to decide which territory he or she can hold. And in the same reason, a good franchise agreement would also provide that the franchisee should not have at all times or at any time a discretion na magpalit ng location. Kasi others would say, teka lang, parang pagka the sales is quite low, they would blame the location. No, it's not like that because yung assigned territory is well thought of based on gathered and accurate information. So the franchisee could not use it as an excuse for low sales. That's the importance of including assigned territory as part of the franchise agreement. Next is one basic part of a franchise agreement is the duration of the franchise and the renewal right. Of course, we usually have the period stated in the franchise agreement for how long it would run at the initial signing and how long will it be renewed for another term. Now, usually renewal would entail in the usual franchise agreements that we have made for our clients. The franchise fee will be at 50% of the prevailing franchise fee at the time or at the date of the renewal. So this is the exception doon sa na-mention natin kanina na one-time payment ang franchise fee because every renewal is considered as a new contract. Okay. Next is the training on ongoing support. Okay. So, na-mention ni Joms kanina yung corresponding obligation ni franchisor to provide training and ongoing support. This is to ensure that the quality of the product is preserved, or the product and the service is preserved. It's not just for the benefit of the franchisee, kasi sometimes the franchisee would just be dependent fully on the franchisor, like, oh, sila naman na may alam dyan, so they would provide us naman training, may support naman. The franchise agreement should specify kung ano lang yung training that would be made available to the franchisee at ano yung klase ng support that also would become available to the franchisee. Because of course, you do not guarantee the success of your franchisee. There's no commitment as regards to that in any portion of the franchise agreement. So it is really a joint and collaborative effort on the part of the franchisor and the franchisee to make the franchise a success. Okay. So next would be the advertising. We have usually a national and local advertising and a fund specifically earmarked for this purpose. So a good franchise agreement must educate the franchisee of the importance of advertising to the business. And it must also specify certain portion allocated for local advertising, and on the same vein, certain portion allocated for national advertising. This is usually computed at the gross sales. So the local advertising, it's not collected by the franchisor, but the franchisee has to undertake, has to commit na talagang gagamitin niya yung portion earmarked for local advertising to advertising itself. Kasi you can check naman how much has been spent for local advertising. If none has been spent, then it's part of the breach of the agreement. Okay. So those are just the usual provisions that are very important and significant to a good franchise agreement. But I have to tell you this, a good franchise agreement, hindi lang siya mahaba. Dapat kumpleto talaga siya. Kumpleto siya in such a way that lahat ng issues, potential issues, problems, or instances that could come up and that could arise between the franchisor and the franchisee, dapat na project siya ni franchise agreement. And not only that, hindi lang dapat na project, dapat meron siyang corresponding remedies and solution to the problem. The problem of a very general and short franchise agreement is nakalagay doon si franchise fee, kailan magbabayad, kailan mapag-na-late, kailan may interest, or things like that. But the thing is, some franchise agreement overlook the facts. Like, for example, paano kung naging incapable si franchisee? Or for example, let's be pragmatic about it. But paano kung namatay isang party, si franchise or si franchisee? Does the franchise agreement provide a remedy or how to address that kind of solution? Or for example, si franchisee mo is just the one who dealt with you is just a minority in a corporation. Or kaya, when he signed the contract, he was a majority shareholder. But along the way, nung nagpa-franchise na siya, binenta niya yung shares niya. So parang 10% na lang yung shares na from the corporation. So anong effect nun sa franchise, di ba? We all know that if you're not majority, if somebody else holds the majority in the board, they could cancel the franchise. They could say it's not profitable anymore, or we have things like that. They could come up with reasons not to honor or to dispute what has been entered into by the minority shareholder. So a good franchise agreement has to have provisions that should address this. And our franchise agreement ensures that all possible instances that could occur between the franchisor and the franchisee has all these solutions. Okay? So with that, let's jump off to the usual legal problems in franchising. Now, you have to believe me na napakarami ng potential problems in a franchise agreement. Yung simple nga na deed of sale, which is just a transfer of property for a fee, for a consideration, ang dami ng potential problems. How much more in a complicated relationship arising from a franchise agreement? Complicated in such a way na hindi naman siya mahirap. Hindi siya, not to discourage you, hindi siya mahirap. But there are so many complexities that could happen along the way that could be a source of potential legal problems. These are the examples. Okay. Of course, there could be a delay in the delivery of the supplies, and of course the delivery of the payables. Delay in the royalties, delay in the advertising fees, yan. So yung franchise agreement natin, may solution na for each. For example, may delay si royalty ng payment, may automatic na doon interest for penalty. So, sige, ma-delay ka, okay lang. That interest would accrue, and mata-charge ka namin. So, anything we can hold yung supplies para hindi ka na makapag-incur ng additional obligation. So another thing is misdeclaration or under-declaration of sales. This becomes relevant doon sa pag-compute ng royalty fee based on the sales. If you have yung mga ERP system that would provide you a real-time access to the sales of the franchisee, well and good. So mababawasan yung opportunity, window of opportunity for the franchisee to underdeclare or misdeclare. Or for example, if yung computation yun ng royalty fee is fixed, for example, you don't take into consideration yung gross sales for a month. Basta naka-fix tayo at 10,000 a month, whether or not your sales is this much or this low. So pag ganito yung provision nyo for the payment of royalty fee, then you're safe against misdeclaration and underdeclaration of sales. But then again, for those cases na talagang merong potential violations committed through this underdeclaration ng sales para makatipid sa royalty fee, then the good franchise agreement would also include the remedies available kay franchisor para ma-address yung ganito. Well, automatically, of course, that is a ground for termination of the contract. But then again, when you say termination, it's not as easy, di ba? The termination has a separate procedure in itself. So the franchise agreement, for example, considers misdeclaration as a ground for termination. Then what will the parties do if it's already for termination? So the franchise agreement should also delineate the procedures or the steps to be taken in the event of this kind of breach. And then one other common problems that usually come up in a franchise agreement is the mismanagement of the franchise. Mismanagement can come in various forms. Whether nagpalit ng management, tapos yung pinalit, hindi na training because walang proper information, walang proper communication kay franchisor, or si manager or the owner of the franchisee got into legal problems. Nagkaroon ng bankruptcy, nagkaroon ng receivership against their corporation, so napabayaan si business, or nagkaroon ng maraming business nagkautang-utang, napabayaan. In other words, napabayaan for whatever reason, napabayaan si franchise. So what will the franchisor do? Doon sa franchise agreement natin, there are several options. Pwede kang mag-take over. You take over the operations of the franchise. Ikaw na yung mag-provide ng personnel, ng management, at all costs charged to the franchisee. Meron na rin dyan naka-fix how much yung charges mo per day or how much yung additional mo na charges or additional fee sa royalty if you want it charged up sa royalty. So, pwede rin siya na pag may mismanagement ng franchise, pwede may right si franchisee to assign it. O sasabihin mo, o sige, franchisee, since you were doing well naman from the beginning, nagkaroon ka ng mismanagement, now I will give you the right. Meron ka bang kilala who is who is viable to operate this business. So you can also, the franchise agreement, depending on your discretion or sa agreement sa discussion and terms, can provide the assignability of the franchise to another person provided may consent si franchisor. Okay? So one other usual problems naman is the unfair competition. Like what Joms have mentioned, the unfair competition can occur also in many forms. But one good example would be coming up with a product similar dun sa franchise product, but of course sourced somewhere else or produced by them, by the franchisee itself. So that's also unfair competition. O kaya creating another brand that is closely similar pero under a different name. So those are forms of unfair competition. So meron tayong provisions in our franchise agreement how to address this. Merong automatic na liquidated damages for that. Meron din naman siyang provision for automatic takeover kasi minsan it is not readily advisable to terminate the franchise kasi kung maganda yung kita eh. So of course, hindi lang naman to puro usapang legal. This is usapang business. So if maganda yung kita pero may ginawang violation si franchisee, what can we do? Instead of terminating it, let's have automatic takeover kasi may breach siya. So you will be the one assuming the entire operations. Kahit wala ng damage, pero you assume walang cost. Yung assumption mo and yung assets that you took over, yun na yung magko-compensate for the damages committed by the franchisee. Okay. So let's go to the other areas of concern in a franchise agreement. First is the intellectual property rights. Like what I have mentioned earlier, bakit importante is intellectual property? I really hope that by this time, all of you have already registered your trademarks before the Intellectual Property Office. The importance of this is, for example, you're operating your business na under this particular logo for 7 years, for 10 years. Pero late, hindi ka nag-register. And then there's another business similarly related to the products or service that you offered with a similar or closely may resemblance dun sa logo mo or sa brand name mo. Then nauna siyang nag-register. So the first one, kahit may prior use ka, if the other business registered first, then legally sila yung may right over that logo, over that brand. So sayang naman yung 7 years or 5 years that you have invested in putting up that business and in making sure that the name and the logo becomes known within your locality or within your area of marketability. So that's the importance of intellectual property rights in expanding your business. And like what I've mentioned earlier, may separate goodwill value ito. Yung logo nyo lang, if 10 years ka na, or sa business, if you sell it to another, if you sell the entire business, may separate value yan. Just to cite an example, I have a client. It's a big school, and we're trying to sell it. The name itself, the goodwill itself, already commands 300 million pesos. So name pa lang yun. There's no asset attached to it. It's just the name and that's it. The goodwill. There's an actual and accurate computation of goodwill under the law. So it's how important registering your brand or your trademarks is before the Intellectual Property Office. Madali lang naman. You just need to come up with an accurate description of how your brand or how your trademark looks like, what colors, and then what products it cover. And then you file an application. Pag may mga challenges, then that's just when you face the objections. Pag may mga kaparehas, you'll just explain how different your marks or your mark is from that competitor. Okay. Next would be the another thing pa pala is the infringement. If you are registered before the Intellectual Property Office, meron ka ng right to ask any other businesses using the same logo or at least closely similar logo to cease and desist from using that same logo in their businesses. Kasi what they're doing is actually an infringement, and it can be filed as a criminal case before the fiscal's office. So ganun ganun yung extent ng protection accorded by the intellectual property law once you have registered under it. Okay, next is the e-commerce law. Now, simply speaking, the e-commerce law, when it was enacted into a statute or into a law, it made all electronic data, messages, exchange of communication recognizable under the eyes of law. Kumbaga, nag-text ka, nag-email kayo, or nagbenta ka online, that could become a source, a legal source of obligation. So, if you're engaged into marketing and selling or distributing your products or services online, again, I advise that you have fine prints indicated in your web pages or Facebook pages or any other social media platforms that would limit your liability. Para hindi, for example, hindi lahat ng makausap nyo doon would think that they already have the right over a certain product, or baka they would think that you have warranty or extensive warranty over the product that you sold. So dapat dun pa lang, meron ng fine prints on how to deal with this kind of potential issues. Because with the way that the market is evolving right now, everyone is online. Even as lawyers, our hearings in courts, we conduct the same online. So, kumbaga, it's very, the extent is very wide, very broad. It's all communications exchanged through online portals. They are considered enforceable under the law. So, of course, we have to be cautious. We have to make sure that we are adequately protected in all our dealings online. Okay? Next is the labor concerns. Okay, na-mention ni Joms kanina, so operating manual, merong separate module for human resource. That's one important portion of the operating manual. Kasi even if we already know the fact that the franchisor is separate from the franchisee, so much so that the employees of the franchisee are not employees of the franchisor. But then again, the franchisee, sabi nga ni Joms sa example niya, the franchisee could always come up with an excuse na we were not aware because the entire system was just passed on to us by the franchisor. But then again, you have to understand that as you actually decide to come up with a operating manual of your franchise, the details of the labor standards and procedures, it has to be indicated, embodied in the operating manual. Okay. Another reason why this is a relevant law in franchising. I have an actual case which I always share with our clients and our participants, that I have an actual client for franchising. Si franchising naging very busy. So, nag-grand opening, nag-commence operations, very busy si franchisee. So, si franchisor was forced to assume the operations. Siya yung humarap sa grand opening, siya yung nag-open up, nag-start, and all that, just in consideration of the franchisee. Kasi, they're friends. You cannot avoid the fact na magpa-franchise sa'yo, minsan friends or family. So, sige, accommodation. So, itong si franchisee, took advantage of the fact na si franchisor naman nag-ooperate. And then, may na-miss na labor issue. Nagkaroon ng labor claim si one employee against the owner of the franchise. Now, to the mind of the employees, the owner of the franchise is the franchisor kasi siya yung nakikita, siya yung visible and regularly present. So what happened was, the franchisor was sued before the National Labor Relations Commission. So it's easily defensible naman because of course under the law, wala kayong employment relationship with the employees of the franchisee. But then again, to be dragged into an actual case before the labor, hindi ka naman readily ma-dismiss or you won't be readily excluded from the case. The arbiter would have to consider first evidence if you're actually not part of it. And while it's ongoing, you have to attend, you have to spend legal fees to have someone handle the case for you. And of course, we don't want legal expenses. It's the last on the list on our business operations expense, okay? Okay, so the last part is the franchise corporation. Now, what's the difference between and among a sole proprietorship, partnership, and corporation? Of course, most of you would already know this. Si sole proprietor, isa lang siya, and he registers his business before the Department of Trade and Industry. Si partners naman, 2 or 3 or more people come together to form a partnership. Nag-pool sila ng fund. But also, you have to register this with the Securities and Exchange Commission, or the SEC. And it also carries a name different from the names of the partners, the individual partners. Now, si corporation naman, closely similar to how a partnership is registered. But ano yung difference? Sa partnership kasi, why it's not readily advisable by lawyers, si partners, once si partnership business nag-incur ng liability to a third party, say supplier or contractor, and then natalo kayo in a claim by that third party, your personal assets are not readily protected from that claim. So, ibig sabihin, meron kang kaso sa court, si partnership, yung bahay mo na nakapangalan sa'yo, not naman sa partnership, pwede siya ma-drag into the case and maging subject for execution. So that's one danger of partnership. Whereas in a corporation, meron siyang cloak, meron siyang shield from yung personal assets ni stockholders are not accessible to those persons who deal with the corporation. It would take a lot of effort, legal efforts, and a lot of evidence to prove na liable si personal assets ni stockholder. So that's the beauty of having a corporation. Now you will ask us, bakit kailangan may SEP? Attorney, meron na ako existing corporation. Why is there a need for another corporation? Additional gastos lang yan. Well, and true. That's true. Gastos na naman yan for registration. But then again, in the long run, as if you really intend to grow your business, it would be better. Why? First, in your existing business, you are marketing, you are selling, you're distributing your product and your service. Whether it's food, whether it's a spa, then whatever service you have. But in a franchise corporation, you are selling the business itself. You are selling the viability, the profitability of operating your business. So, 2 different products. It's not against the law that you operate it in your existing corporation, but practically speaking, it would be best to have a separate corporation. Why? Apart from the fact that separate yung product that is being marketed and sold by 2 corporations, when it comes to your books, it would also be best if you have 2 separate books for 2 businesses. Para whatever contracts that the main business is undertaking is separate from whatever the franchise corporation is undertaking. Walang commingling of funds, walang commingling of employees. For example, sila Joms. Joms is a separate franchise corporation. He only has 6 employees sa franchise corporation na, and it's separate from his main business. So the operation of the franchise corporation is very small. Yung labor standards and yung mandatory statutory benefits under the law is different when it comes to the franchise corporation kasi 6 lang yun eh, as opposed to, for example, 50 employees which you have in the main business or 20 employees. So mas magiging practical siya if you really separate it. And of course, one major importance is pag nagkaroon ng kaso si main business, for example, for whatever claim that is attached to the product itself, o parang nagkaroon ng problem, or may nagreklamo sa product, parang may mali, or the quality is not that good, or the procedure had during the transaction was wrong. So may kaso sa inyo dito sa main business, of course, covered and shielded itong si franchise corporation. So those are some of the practical reasons why putting up a franchise corporation is actually advisable and essential if you're actually deciding to expand your business or to grow your business through franchising. Okay. So as an update, that concludes my portion of the discussion for today. But as an update, we have been informed that the government is already intending to come up with a law, introduce a bill and then approve a law that would authorize the DTI to regulate franchise businesses. Kasi nga nagkakaroon ng mga pseudo franchisors that for 15,000 you can come up with a business, but the protection towards the franchisee and also the franchisors and most especially the consumers are very limited. So when the government comes in, the DTI intends to check the completeness and the efficacy of your franchise agreement. So that's just one recent update for franchising. So that concludes my discussion for today. So I just want to share with you this. At the end of the day, everyone is responsible for their own contracts. Nobody forced us to sign them. So even if you do have your own lawyers to advise you, of course, you yourself has to understand what's in the contract and what's the importance of the contract. So that's it. And thank you for listening.